ladies and gentlemen. It's a pleasure to welcome you to this evening's program, Views from the Court with Judge Gonzalez-Rogers, Judge Gilliam, Judge Ryu, and Judge Westmore. Thank you, everyone, for braving the elements. It's been a tough day, and I appreciate you coming out. For those of you who are federal bar members, thank you for coming. And for those of you who are not yet federal bar members, I encourage you to join. On your name tags, you'll see those of you who have logos are members of the federal bar, but those of you who are not, we need to have you join. The federal bar is dedicated to promoting the welfare, interest, education, and professional development of attorneys who practice in federal court. We have over 19,000 members nationally and over 2,000 members of the judiciary. The federal bar serves as a catalyst for communication between the courts and the private and public practitioner. We work to protect the rule of law through education, leadership, and nonpartisan advocacy. On the flyers that I handed out, there's a QR code that you can scan, and that will allow you to join the federal bar. For those of you who are law students or law clerks, you're entitled to free membership. For law students, you have free membership throughout the 3 years of law school and your first year of practice. As the president of the federal bar last year and this year, it's been my goal to present a lot of programs, at least 1 or 2 programs a month. The flyer highlights several upcoming programs. For March 6th, it says that it's going to be a Me Too, what is the Me Too movement in 2025. That program is going to be on civility, and the flyers should be going out tomorrow. We also have a special program that I'd like to highlight, which is Join a Judge. It's a program open to attorneys who are in practice less than 7 years. It's a small group of attorneys who then meet with judges. Judge also posted a program of 8 attorneys in the summer. Judge Donato has done it. And we have 2 programs coming up, one with Judge Davila, February 20th in San Jose, and Judge Chen, February 25th here in San Francisco. There is 1 spot available for Judge Chen, and we have several for Judge Davila. So I encourage you to join that and tell attorneys in your firms who have less years of experience to look out for the Join a Judge, because we're going to try and hold those at least once a month. As far as this evening, after the program, we're going to be hosting a reception in the attorney conference room, which you just go down all the way down the hall, make a right, and you'll find it. For those of you who are staying for the reception, you have to leave through the elevators by the attorney conference room. If you're not staying for the reception, you also have to leave through those elevator banks. You cannot leave in the way that you came in. The elevator banks by the attorney conference room will let you out in the rotunda, and you just follow the signs for the exit. Our moderator today is Ellen Leonida, who's a partner at Simon and Bancroft. Ellen is on our executive committee and was very interested in moderating this program. I'll now turn it over to Ellen. Thank you.
Thank you. Not because I do all the things wrong that you're about to hear about it. So before we get going, I want to introduce the 4 people who we need to be introduced in this room. I'll do that quickly, and then we'll get into the questions that we have. And at the end, we'll leave hopefully some time for questions from you all. So here we have Judge Yvonne Gonzalez-Rogers. She was appointed by Barack Obama in 2011. Before that was a judge in the Alameda County Superior Court, and before that did complex civil litigation at a big law firm here in San Francisco. Next is Judge Donna Ryu, who has been appointed since 2010. She also was a civil rights litigator and a law school professor before she took the bench. Next, Judge Gilliam, appointed also by Barack Obama in 2014. He spent 7 years with the U.S. Attorney's Office, and before and after that was with a big law firm doing white-collar law, which is a really good lesson in why you should be nice to the people that you're opposed to. And last but not least is Judge Candace Westmore, who has been a judge here since 2012. Before that, she was with the Oakland City Attorney's Office. Before that, civil rights litigation. And what I am just guessing was the best job she's ever had was as a law clerk at the Contra Costa County Public Defender's Office, when I was a public defender there. So let's get started. And first I'd like to talk a little bit about motions. And we'll start with Judge Gonzalez-Rogers, but hopefully everybody will pile on with the answers. Judge Gonzalez-Rogers, what do you want lawyers to think about before filing a motion?
Well, I first want to again thank you all for bringing the elements. As Candice said, I spent a bunch of hours here in Portland today, but when I went back in the chambers, it just was raining cats and dogs. So pretty amazing that you all made it through. What I'd like you to think about in terms of motions is how does it really advance the litigation? You know, there was a point in time in our history as lawyers where we didn't file 12b6 motions. We didn't file them. Now I understand, you know, it's almost as if everybody feels compelled to file them. Why? Why is a big question. Push back on your clients. What are you going to get out of it? Let me tell you, we have hundreds and hundreds of cases, and people want responses to their motions, and some of them really do need responses from us. That is, some of them really are, you know, the claim shouldn't be in court in the first place, or it's really going to impact the ability to settle it. But routine motions for just because you can file it is a waste of our time, it's a waste of your time. And it increases workload, so we can't get to the really important things. I think the other thing is, when you have a targeted motion, a judge is going to pay a little bit more attention than just a, you know, you're trying to challenge every single cause of action brought. If you can just say to the judge, look, they brought 10 causes of action. 3 of them really should be dismissed so we can make more efficient use of our time. Focus on the 3. Get a win on the 3. But doing 10, when we have a staff of 3 and hundreds of cases, that's what we have. Remember, we have 3 law clerks. That's all. Or 2, we'll do much research. So anyway, that's what I want you to think about. Think about being more efficient.
I'll chip in for a second and welcome first to the beautiful Oakland courthouse. We really relish the opportunity to get a chance to interact with you. So thanks for coming with a friendly court. And we all really like each other. And I'd like to introduce someone to you who's sitting over there. She's going to be, she can't stay for the whole time, but this is Judge Araceli Martinez-Ordin, appointed by President Biden. And although she's not up here speaking, at least you get a chance to see her, she'll recognize her. When you appear in front of her, either in San Francisco, where she officially says that she's sometimes over here. So, part of what I think Judge Gonzalez-Rogers is getting at is this focus or efficiency goes back to Federal Rules Civil Procedure 1, that we're all responsible. And actually, it was amended in 2015 to make you responsible as well, to try cases and litigate cases in a way that's just and speedy, inexpensive. So those are really our mantra for how we are looking at cases. We're trying to manage them fairly. And so a lot of the motion work in Rule 12, I agree that you can talk to each other. And sometimes I'll see that back and forth in the docket. There'll be a complaint and then, stipulation for amendment. I love that. You talked and taking care of the problem. And you don't need to get the court involved. The other thing that really puzzles me is when people sometimes go for a Rule 12, and because we have very, very permissive amendment in the Ninth Circuit, right? It has to be futile. If it can be amended, unless it's really late in the game, we have to allow amendment or it's reversible error. So when I see a defendant go for Rule 12 on certain claims where maybe the plaintiff wasn't really queuing it up correctly, but now they are, now they've really thought it through. It's like, why did they do that? And now they've gotten an opinion that really lays it out. I'm not sure. Strategically, it's not always the best idea. We're going to talk about discovery in a little bit. That's another place where motions or motion work. You want to be really careful when you're doing it and that you're doing it with purpose. And then lately, the other one that I see that see regularly getting turned back are motions for preliminary approval of Rule 23. I get the sense sometimes that people have rushed to get to the settlement, now they want to get in on the books, and the papers are a little sloppy. They've got typos, they haven't thought about the guidelines that we have on our website about the things we want you to address. And it's not sending a great message about council, you know, whether council, because we have to evaluate you as class council under Rule 23. So take your time, take a beat on Rule 23, polish up your motions before you file them, and you have a better chance of getting it through the first go around instead of
Yeah, I can't emphasize enough the importance of keeping Rule 1 as your guidepost. You know, whenever you're making a decision, whenever you're coming up with a strategy, think about whether or not it actually serves those purposes in the rule. And to, you know, just remember that we are very visible. Just as Rogers has said, I mean, we have a massive amount of work, a massive amount of cases and motions before us. And use the meet and confer process. That's why we see it in the Federal Rule 37. That's why we see it in the guideline, our Northern District guidelines for professional conduct. That's why you see it referenced in civil local rules. That's why we see it referenced in our standing orders, because we're trying to say it so many different ways, under so many different circumstances, that you really should be meeting and conferring with one another as part of the civility and the practice of law. And it's not just, you know, saying niceties to each other. It's really collaborating and working together. And you can agree to disagree and still work together and talk through what some of the issues are. And the best lawyers that appear before us are the ones who take that to heart and do meet and confer before filing motions, which is required actually under our Northern District guidelines, that you meet and confer before filing a motion. And so the good ones do that. And then those are the ones that we see who will narrow the issues as much as they possibly can and avoid filing a motion altogether and simply stipulate to an amendment that they have discussed or decide not to file a motion at all. But I do see the issue that Judge Ryder just brought up where, you know, sometimes it's just a knee-jerk reaction that because I can file a motion to dismiss, it's just part of litigation, I'm just going to file a motion. And we would really appreciate it if you do not do that and followed our requests that you meet and confer and work together to accomplish the goals of Rule 1.
I agree with all that. The one thing I would add on the point of what to think about before filing a motion is think about the standard of review and think hard about whether, given the standard the judge is going to have to apply, it's worth making. So, for example, in a summary judgment motion, everyone knows, got to take the evidence in the light most favorable to the non-moving party, and it's not a place for credibility determinations, for example. But very frequently we'll get that sort of motion, where the idea of, well, Joe said this and Jane said that, but no one can believe Joe about this. That's not the place. And so, really, I think analytically that's a helpful process. Have that squarely in mind and really think about, can we bring a meritorious motion while we're still adhering to the standard of review? Because the court's going to have to do that. Motions to dismiss are the same way. You take the allegations as basically true. Formally, you know, a few around the edges formally exceptions. But so think about that when you're doing the calculus suggestions. Also, Rogers is talking about is this worth doing, and can we do it with a straight face in a way that will respect the standard that the judge has to apply? The other thing is, please think about not filing a motion to strike allegations. That probably is one of the most litigation motions that we see. I don't think you're going to see a lot of those granted because the standard is high, and ultimately that's squabbling about the pleadings. We're trying to get to the point where we can get to the merits and tee the case up. And so that one in particular, I think if you look at opinions in our district, you'll see a number of judges commenting on the limited utility of that motion. So keep that in mind.
So on the topic of summary judgment motions, how many do you like to see? How do you feel about multiple motions on the same issue, multiple motions from defendants on similar issues? Maybe start with you.
The rules, one per side, because they are really, they take a lot of time. So I don't have it in my standing order, but I tell people in CNCs right away. I do make some exceptions because occasionally there's something that really serves an early decision that might end the whole thing. Statute of limitation, for example. Something key, I'm going to make you really explain it to me to get permission to do it, but occasionally it does make sense and serves the whole way. It's really helpful when there's multiple parties for you to coordinate so that we're not getting multiple briefs from many parties on the same issues. And I get it because I was once a litigator. It means you've got to take extra time to litigate and to coordinate with somebody else and to build in time to get it all in brief. But what I'm going to suggest is I always learned that when you're presenting something to the court, make it as easy as possible for the judge to rule for you, right? So the way to do that is to present something that looks good, that's easy to analyze, that is helpful. And if that takes a little extra time on your side, it's worth it. We so appreciate it. The coordination, of course, if we see it coming, we're going to order it anyway. But if you do it thinking ahead and bring it to your attention, extra bonus points. The ERISA lawyers who do the denial of benefits, they all are, by and large, great at presenting at case management. Judge, we're going to do cross motions, we're going to do 4 briefs, not 6. And we agreed on this schedule, and boom, we love it. Thank you very much. Then we're not spending extra time on, talking about the same thing with lots more paper. It's not really helpful.
Even for most of us require only allow one motion for summary judgment. I do have it in the standing order, just to let you know. We only get one. I also put it in my case management order after the first case management conference for all the same reasons that Judge Reed mentioned. But there are times when it's warranted, and so you have to just get through the court to do it. So, be judicious about filing those motions.
Related question, how annoying is it when people don't read your standing order?
Very. It's a daily occurrence. Not all of you.
It's interesting because for me, that comes up at the very first case management conference, because part of what is the parties are directed, as all of you know, is to meet, confer, propose a schedule for the case, and that's one of the main things we're going to talk about. My standing order says that there needs to be a certain amount of time between the dispositive motion hearing and the pretrial conference. Maybe 50% of the proposed schedules comply with that in the first go-round, and then I have to send the parties back, and I usually say either you can confer and come up with something that complies with my standing order, or I'll just impose it. But that's a place where it's easy to look good. The very first appearance, we read the order, we're communicating with each other, we know what we're doing, and if I get something that doesn't reflect the standing order, then that sends the opposite message.
It's little things like changes conference, provide the change. In my standing order, it says that I want a Word version emailed to me. And I can't tell you how many times it's not done. But I love all of you who do follow my standing order. Thank you so much. It makes our job so much easier. We really do spend a lot of time working on our standing orders. The court has its standing orders for all judges. We have all of our different standing orders for various different things that we're going to be doing before us. And we spend a lot of time, we talk with our law clerks about what works. We base what we put in our standing order on our experience dealing with these cases, what makes things more efficient for us so that we can get through all of the cases. makes my day when I have people appear in front of me and it clearly read my standing order. It could be something as simple as I'm on a call, a pre-settlement call, planning for a settlement conference, and that person has clearly read my entire settlement conference standing order and is prepared to discuss everything that needs to be done to get ready for a meaningful settlement conference. And I'm just so excited. I mean, it only takes something that small to really make me happy.
You know, I understand that you all probably don't like our session. You know, the local. But this all goes back to us wanting to be efficient, to get through our motions list, to actually respond to everything you're giving us. That's why we have them. Because, you know, over the years, as you've heard, we figured out ways to be more efficient. And we're trying to communicate those to you in our standing orders. And we all operate differently. We think differently. We work differently. That's why we do what we do. We aren't doing it to annoy you. We're doing it because we're trying to do our job more efficiently. And I won't talk about summary judgment, but read my standing order because I do it totally different. There's plenty of seats if you want to come on.
And I'll just say, I don't know if they really annoy you or not, but when I was practicing, I know. Well, you know, I used to appear in state court and federal court, and so I was actually exactly what. And one of the reasons why I chose to apply to the federal bench is because I just really appreciated the clarity that you get in federal court. You have your federal rules, a civil procedure, you have your civil local rules, you have the standing order, sometimes a general order that applies. I mean, everything is prepared for you when you are practicing in federal court. And I loved it. I felt like it was very educational, you know, all of the orders that came out from the judges. And sometimes I think that's why you file motions, because you just want to see what we have to say about your case. That's the unspoken thing. But I really did learn a lot from every order that was issued by the judges. And I don't mean to encourage you to do that, because we don't have to be such. We're doing that to give you sort of a bird's eye view of how we look at your case. So that's not a good way to use motions. But I don't know if you find it annoying or not, but for me, it was just really informative and educational, and it made my experience as a litigator all the better to have the standing orders, because you need to know what each judge you're appearing in front of would like to see. And so there it is, all laid out for you, and all you have to do is read it.
So once they read the standing orders and they met and conferred, filed a really probative motion on a targeted little issue, starting with the briefing, just getting in what works and what doesn't for you in a brief.
Yeah, so I'll have a few, and then I'm sure we'll have thoughts on this front. I mean, really big picture, and this goes to something that you hear as a theme, is consider the purpose. The audience and the things that I find helpful in a brief is a really well done summary of argument, just sort of up front. Here's what the motion's about. Here's a short recounting of our position. Here's why it makes sense. Because, you know, another thing you'll hear is we have a lot to do, we have a lot to read, and so not having to go treasure hunting to find out what the purpose of the motion is and what the key arguments are, I find to be really helpful. My theory in advocacy, especially written advocacy, is show, don't tell. That the more you can make the facts and the law work for you to lead the judge to the conclusion that you think is right, the more persuasive your papers are. Characterizations really, and sort of, I'm sure we'll all talk about the adjectives and the adverbs and the invective and all of that stuff, and all of that makes your brief harder to read. And so to the extent that you can lay out what happened and why the law cuts in your favor in a way that is, it's not neutral, of course, nobody's neutral, you're all advocates, you're supposed to be advocates, but in a way that makes it as much about, it leads us to see it as self-evident without having to say, or characterize it, or attorney argue your way there, I think is always really helpful, and so that idea of show don't tell, I think is a good one for me. Few little myths. String sites without anything about what the cases are about are really unhelpful. Make it pretty hard to read. If it's worth putting in, either talk about it in the text or at least have some sort of parenthetical that tells us what it's about. Lots of the string sites with no detail is unhelpful. Persuasive authority. We get tons of it. And in certain types of cases, most of what we're being cited is district judge in San Diego said this, another district judge in Sacramento said that, all of which is fine. Sometimes there's no controlling authority. But if it's persuasive authority, be sure you explain why it's actually persuasive. It's not meaningful that another judge said it. I might agree, I might disagree. I'm not bound even by my own rulings on the issue, let alone the issue, the rulings of my colleagues even in this district. And so don't forget, that it's one thing if there's a Ninth Circuit or Supreme Court case on point, but if you're using persuasive authority, use it to persuade things. That means explaining why it should be followed. And then one last one, common issue, requests for judicial notice, ubiquitous, especially on motions to dismiss. There's a Ninth Circuit case called Koja, and I would encourage everyone to read it really carefully and make sure that the way that you're trying to use a request for judicial notice complies with it. Because very often we get motions to dismiss that are motions for summary judgment in disguise using the principle of judicial notice. And the Ninth Circuit, in no uncertain terms, laid out in that case, I thought very well what we can and can't do to make sure that you're staying on the right side of the line. So just be sure you're not defaulting to judicial notice as a way of actually, to the point I was making earlier, defeating the standard of review that the judge has to apply at the motion to dismiss it.
Yeah, I would say, again, remember that probably the first person to read your brief is not me, it is my law firm. And these are all young people, 2-3 years out, they're very smart, frequently smarter than some of the seasoned people in front of me. So very smart people, but they're still young law firms, right? 2 to 3 years out. And what I teach them is block and tackle. You have to think about what the law is, because frequently we get briefs that are just all over the place, that assume that are very confused and don't put things in the right context. So identify what the law is. What are the elements? 5 elements. You're moving on one of the 5. Tell us what the elements are. Tell us what you're moving on. Do the analysis, conclude it, and move to the next. Again, cut the hyperbole. I don't care about hyperbole. And by the way, clear, the word clear in your briefs is usually a signal to me that it is not clear. And that's why you're focusing on that word. By meaning there's other ways to use it, just avoid the word clear. But really think about clarity in your presentation. What's the law say? That's what I always want to know first. What is this? What is the law? Okay, now that I understand what ballpark I'm in, what the law says, now let's talk about the facts. So whether it's a motion to dismiss, if it's a motion to dismiss, then what are the allegations in the complaint? Where did these things show up in the complaint? If it's summary judgment, what are the facts? I need the evidence. Bring me the actual evidence that they're giving me. So think about it in that kind of, at least with me, block and tackle type mentality. Footnotes. Do not put substantive argument in your footnotes. That's not the purpose. And if you're trying to get around page limits by using footnotes, there are plenty of judges around here who will strike pages. That's a lesson that you cannot avoid page limits by putting things in footnotes. What do you think?
Yeah, here's what I'd add. This block and tackle idea, I think in my chambers we call it, maybe, talk about the same thing, pinning something to the mat. We sometimes get briefs that are very hard to understand. Sometimes I think it maybe it's on purpose. Sometimes it may be a litigator's goal to obfuscate. It's and our job in chambers and working with my law clerks is just to tackle it back, pin it down to the mat, right? What are the elements? What's the standard? What are the facts? And you know you've overstepped when you get an order from me that says, this side appears to argue, blah, 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 or seems to argue. You can't even tell what your argument is. It's an issue. Versus, what I love is a brief that makes me feel smart. A brief that's a pleasure to read. You know what that is, because you were all in law school when you read stuff and thought like, what is this? In case books, really dense things that make you scratch your head, versus things that you can really engage with because they make sense and then make you feel smart. So the things that have that quality are, where you've got an opening that has a roadmap, you've got a great table of contents that explains where this is all going, you've got the ask, this is what we want with this, and the writing is clear and concise. Every spare, a word that doesn't get you somewhere is taken out. Appellate courts often use word limits instead of page limits. I love that. Because, and I'll work with my extras sometimes and say, they give me their first memo, I'll say, okay, now go back and take 500 words out. See what happens. It makes it so much easier to read. It makes your writing more lively. It makes your reader want to engage and pay more attention. It's worth it to spend time to have an excellent brief that has exhibits that are not just jumped together, but have tabs, and if it's depositions, they're highlighted. Again, back to make it easy for the judge. Point it all in one direction. Roadmap, exhibits. Here's the ask, voila, right? So, we'll be talking about oral argument in a sec, but don't assume you're going to get oral argument. Your briefs matter. You've got to put everything there because you may not get more. So don't just send a draft in. Really give it your best effort.
I don't really have too much more to add to that. I think we sort of checked off all the issues. I would just emphasize, as you're pinning something to the mat, that you make sure you're not making misstatements of the law or the facts. And it's just surprising to me how often that happens. And when you are giving us what the law is, and then you're giving us citations, I hope you've just really done your homework to make sure that you're not cutting and pasting from some other brief or something where you saw it, and that you didn't really break it down yourself to make sure that your statement of what the law is actually what the law is and how controlling authority interprets that law. Because time and time again, my law clerks who are really busy are going through all of your citations, and yes, they do check every last one of them, and they look at all of the cases that you cited, and they check to see what you have said the case says, and then they check to see if the case really says it. And time again, the citation is not pointing to a case that says what the brief says. It says. So it's really important for you to cut down on the amount of work that we have. It also undermines your credibility with the court when you can't trust what you're telling us. We see so much from all of you who appear in front of us on a regular basis, so you do develop a reputation. And we remember you from case to case. And so, you don't want to be the lawyer that incorrect citations, you know, is another problem in and of itself. Make sure you know how to use the form citation, but then you're also citing to the case, and that the case stands for what the proposition that you're arguing. You don't want to be the one that made that mistake over and over again, because then when we see your name on a pleading or on a brief, we go, oh no, you know, what kind of misleading thing am I going to get, you know, this time? So, or it'll be the opposite of that. Oh, this is, you know, is so-and-so. She always gives me the best, most clear and concise briefs that are so helpful, you know, help educate the court about these issues and what the law is on these issues and what the controlling authority is on this issue. And we carry that with us, so that the next time I see another brief from that person, oh, this is great. So then it's up to you to just disappoint me, but for the most part, you know, we get to know you, you know, and so it only takes one time to just dump something bad on us to ruin your reputation. And as far as giving pinning something to the wall, you have to have the law correct, and then you have to have your facts. And so on summary judgment motions, you're giving us all these exhibits. Well, don't give us 500 pages, because every time someone gives you 500 pages, they're really using everything between the 30 of those pages. But you think that it's okay to just dump a 200-page exhibit on the court, and then oftentimes just refer to it generally with no pen citation to where you want me to look in that exhibit. And then you actually expect me to sift through the 200 pages and figure out where I'm going to find what you're talking about. And I absolutely refuse to do it. And I love this thing that Judge Hamilton came up with. It's called the unusable Chambers copy order. So I use it all the time. Whenever we get one of those giant stacks of paper with no tabs, nothing to indicate where the different exhibits are in this giant stack of paper, and no references to how to find what I'm looking for in the stack of paper, I just fill out that form order and say these are unusable Chambers copies, and I put them in the recycle bin, and I'm not considering it.
So one other thing is, you know, think about sometimes about how you can be creative. This is all back to this fundamental notion of making it easy for the judge. I have in my standing orders requirements for tables, and that's because I'm trying to make it easy for me. I'm trying to help you make it easy for you. So if you have a securities case, you have to identify the specific statements in a table. There's more requirements. If you do the motion for summary judgment, I came from state court. I require a separate statement. And frankly, I read that first because I don't get the hyperbole that I get in the briefs. You can't file a motion for summary judgment without a conference and crystallizing in 3 pages why you think you deserve it. So I'm trying to figure out ways to get you to present evidence in a way that's easily digestible, that helps me focus on what's the core issue. But even if the judge doesn't have that, you might think about, well, how can I make this easier for the judge? Would a table in this case be helpful? Pop it into the middle of your brief. Just, you know, in terms of advocacy, think about, if I know nothing about this case, which the judge may not, how do I get this judge to really be able to get to the point that I need him or her to be? What can I get them to do that? That's your goal, right? You want to set your case apart from the other 500 that are on our docket, or more. Sometimes, but how do you think about being creative?
How do you feel about people that try to set their cases apart by using humor or metaphors sports metaphors or others? What do you think about jokes and things like that introduced?
I don't like it when they do things like, compare themselves to David and Goliath, or, give you this whole sad story about how they're just an abusive relationship with the other side. It's just no drama that is unnecessary, and it's also an insult to people who are actually in abusive relationships. And it doesn't help your cause. You don't need to be melodramatic to get your point across. So I don't really appreciate those kind of things.
I was just going to say, it's risky. Do you want to take the risk? It might land, it might not land. And so do you want to take the risk? Most of the time, probably not. And to judge something that Judge Ryu said that I think is really important, just in terms of structure, short, plain English sentences are great. One idea, maybe two ideas per sentence. That makes it crisp, it makes it digestible, it makes it real. It's not laden down with the heretofores and the forthwiths and all the legally stuff. And just so, I think all of that is to say it's about honing. And sometimes stuff like humor or the joke or the metaphor, you don't know, wait a second, metaphors can get turned around on you if you haven't really thought it through. And so most of the time I find just keeping it pared down, crisp, and to the point is what I like to see, and it makes it easy to digest. There's nothing in it that's going to put me off. Or it's a risk. Do you want to take that risk, or do you want to just be really solid in the way that you present the arguments?
Here's where I've seen it used well, actually, is sometimes in hackneyed cases or misappropriation trade secret cases where there's a concept that's actually kind of hard to understand. Some of the really good IP lawyers weren't necessarily they don't necessarily have science backgrounds, but they're really good at explaining things. And they'll pick an analogy or something that makes sense to bring it down to, to help you understand it. As long you need to pick it carefully, because you don't want to leave an opening for the other side to say, well, that's just, crazy because X, Y, Z. But I've seen that done extremely well to a judge and also to a jury. So I wouldn't rule it out, but you need to be careful to be just.
The brief is in. How important is oral argument? Have you already made up your mind by the time it happens, or do you cancel it if you have made up your mind? How much does it matter?
So I've gotten to the point in the 10 years that I've been on the bench that I will not have an oral argument if I don't have questions. With some exceptions, a number of us do encourage lawyers who are in normal practice to come in and argue, and if parties let me know that that's who they're planning to argue something, and I can accommodate it, I will do that when I can. But really, for me and in my law course, the point of the argument is what questions do we have, and I go directly to them. I say I've got a number of questions, and then we start having a discussion immediately. Like I never have an oral argument now that is an oration. I don't have time. I've got particular things I'm trying to get out of it, and I just go right there. And so the parties that do well at oral argument are the ones who are right there. They understand that I'm asking the questions because that's what's important to me, and they engage. One thing that is a sign of an oral argument gone wrong is when I ask a question and the advocate says, "Yeah, Your Honor, I'm going to get to that on page 2." No, let's get to it right now because I'm interested in it. So let's go there. And so when I do have the argument, it's because there is something that I think is critical that we're trying to figure out that may make a difference. But Judge Ryu is exactly right. I agree. You can never assume, and I think a lot of us, just given the volume of our dockets and the number of things that we have to do, I don't do courts. If I have an argument, it's because I've got something that I really need to do party to it.
I have the same approach as Judge Gilliam. I don't have oral argument unless I have questions, or unless is a motion to dismiss, and I'm considering dismissal without leave to amend, because then I want to make sure I give this an opportunity to talk me out of that, if that's what I'm contemplating doing. But I start off the hearings on motions with questions that I've already come up with in discussion with my law clerks. What are the questions that we have about this? What's not clear? You know, what needs a little bit more fleshing out to understand the positions that are being taken? You know, what are some things we really need to call out on the motion? And so I will start off by saying I have very specific questions to ask, and so I don't want to have just an oration. I just want you to address my specific questions. And then if there are any last things that the parties want to say, I will do that as well. But oftentimes I will issue an order and say, I, pursuant to Civil Local Rule 7-1, I've determined that I need to have oral argument, and I've made my decision, and I give you my ruling. So, you know, the briefs are the most important thing, because, you know, you may not get oral argument. But when you do, you should come prepared to have a meaningful conversation with the court. I see hearings as doing that, having a conversation with us. Be prepared to just talk about the issues. Don't be prepared to give a speech. Be prepared to answer targeted questions. And don't get frazzled by that. So know your stuff, front and back, so that you can pick up an issue right in the middle of whatever you were thinking about arguing, or at the beginning or end, to help the court understand your position.
I share my colleague's approach in terms of when I have argument. What I tell young lawyers when I talk to them about this topic is that try, in terms of oral advocacy, struggle with the gray. And what I mean by that is, frequently we have law that's black or white on either side. And those are the easy cases. Those are the cases where you don't bring the motions, because everybody knows that's what the law says. That fits squarely in there. It goes nowhere, it goes there. We operate in the middle. We operate in the gray. And so frequently the questions are, because a lot of times the questions relate to clarity. But it's trying to engage with you on why your case is more black or more white. And that means you have to take in preparation the position of your opponent, their best case, and figure out how to respond to that. And that's a hard thing to do. It's really difficult. But if you punt on a question and don't answer it, and I'll tell people, no, I'll cut them off. And no, I need you to answer my question. And if you don't want to answer my question, that's fine. But I'm going to go in the back and I'm going to talk to my law clerks about that question. So do you want to be part of the conversation or not? Do you have a response to that question? It is important to know your judge. Some judges are really well prepared. Other judges, maybe not as well prepared. For those judges, maybe you do have to repeat your argument. Maybe you do have to take the court through that. Or maybe they've been in trial all day, so you want to, give them a refresher. You should be looking at your judge's calendar the day that you walk in to see what else they've been dealing with when you step into their courtroom. But other judges have reputations, for being totally well prepared. Have you listened to any of their arguments? Did you stop into their courtroom to see what it would be like? In terms of being an advocate for your client, there's a bit more to it just than what's in your brief. Sometimes it's the best people, the best arguments are those that take the briefs, understand the real weaknesses of their case, and focus their attention there. And give you the reason, you the judge, the reason why, even though it's weak, this is why you still need to rule in my favor. And ground that argument in the law, not in hyperbole, not in ad hominem attacks, not in snarky comments. Because we're not going to do it. That's not a basis for us to rule.
Yeah, in your briefs too, don't shy away from the hard thing. You're all perfectly able to identify what is the critical thing here. What's the most kind of difficult argument you need to grapple with? It doesn't go in a footnote. It's front and center, and you're using the brief to do that, and in an oral argument too. I mean, usually, so I totally agree. It's nice to be able to watch ahead of time to see how judges approach oral argument. For example, Judge White often puts out questions in advance. I've seen Judge Thompson do that too. For me, I'm also prepping in advance and coming up with questions, and really the way I use oral argument is where I need your help, where I really want your input. And I usually cue you in. I'll tell you what I'm thinking. Well, this is what I think. This is my strong tentative. But I want you to, go ahead and try to talk me out of it. What about this case? And I'll point you right to it. And I want you to really, really answer that question, because I'm asking for your help. And if you go over here, I'm going to just take that as, okay, they don't actually have a better answer and pass. Okay, well, then I'm going to just deal with what I've got here. So that listen. That's, I think, the most important thing about oral argument. What is the judge struggling with? What is the other side saying that you need to address? Those are the critical things. Concessions are powerful. If you're asked, hey, I saw in your papers you didn't really respond to this, I'm assuming we can take it off the table. Yeah, absolutely. Or if there's a point that you can concede, it makes you look reasonable. We're not going to waste your time, Judge. Let's move on to something that's got some oomph to it, right? Again, discovery, whole nother thing. You want to be the problem solver. You want to be the reasonable person. You want to show all the ways in which you were really trying to respond to the other side and figure out what is proportional, what is relevant. Here's the things we tried, Judge, and we heard that criticism, so we modified our search to do X, Y, Z. Show us how reasonable you are. That makes the difference in discovery hearings.
Can I say one other really quick thing that could go both ways? We talked about humor metaphors. Citing our own cases back to us can backfire, and frequently does backfire. It does because you don't know that case happening just today. And you don't know that case as well as the judge does. And oftentimes, the case that you cite back to us, or you did in X, Y, and Z, is nothing like the case that's in front of us. So be really careful about that.
One other thing on a small point, but one of the things I will very often ask in an oral argument is, what is your best case that supports this premise, right? Whatever the premise it is. And I am surprised at how often the answer is, it's the Smith case, Your Honor. And I go to the table of contents, and Smith isn't in there. At which point, I ask the obvious question, if this was your best case, how could you possibly not have put it in your brief? Now, I know sometimes as you're preparing for the argument, these things come up, I get it. But if there's any way to avoid having to answer that question that way, it's really helpful. Because I put in all the advanced work, my clerks have put in the advanced work, and we've done that based on what's been presented. So just understand how it looks when there's something that is now pivotal that no one thought to cite in the briefs.
In fact, I think we have at least a draft of an order already prepared by the time we get to the hearing. So we kind of know where we're going by the time we're doing the oral argument.
And if you do find that case, which does happen, I think legitimately in preparing, don't spring it on the other side during the argument. You've been sitting there for half an hour listening to the argument in front of yours. bring a copy, give it to them so that they can respond. Do you think we're gonna not let them respond when you spring it during arguments? No, we're supposed to be fair. We want to be fair. We're trying really hard to be fair. We're not gonna let you sandbag it. So when you find it, send it by email, do something so that the argument then can have some impact, so that we can hear what the other side has to say. Otherwise, we've got to order some formal briefing, and that costs more money, and, just try to be fair.
Or you don't get to have that argument considered, especially if you're raising it for the first time. That whole argument, that should not be happening.
What about cases, and I think this happens rarely in the criminal context, where a lawyer feels like they have to make a motion that is maybe not the most meritorious to maintain a relationship with their client? How do you feel about that? We'll start with JP.
It happens. The magistrate judges.
See how many defense lawyers and prosecutors are in the audience?
Where's our criminal bars? Can have
A lot, yeah.
a few of you. Yeah, you know. Judge Westmore and I, because we're magistrate judges, we're the first appearance, right? And a lot of times the defense lawyers are meeting the client at the podium, or maybe an hour before. We know you're trying to make a relationship. It's under really tough circumstances, and the defendant is, stressed out, and you're trying to show that they can trust you. So I make a lot of, and I know sometimes you're making arguments because you are trying to show your client you're going to fight, and I respect that. But if you're going to do it, do it. Make your best argument. The ones that are halfway don't really accomplish your purpose, and I can't really deal with them with a straight face. I try to help you out. I try to say, thank you for making, despite your strong argument. I never recognize you for your client. Good job. But so that's a real dynamic. I understand it. You need to be careful in other parts of the case. I'll let others speak to that, but certainly in the first appearance, I get it.
I understand it too, but you still have a Rule 11 obligation. And defense lawyers for whom this is the issue with clients, you can't mistake the law just to please your client. It's not ethical. You make the best argument you can make within the context of what the law is. And you can ask to move the law. That's okay. That's okay with me. I understand it. But you first have to tell me what the law is. And then you can say, the judge, there are these other concepts, and we really think you should be pushing. That I can understand. But if you tell me that's what the law is as a way of trying to get around and just show your client, that for criminal defense lawyers in particular, who are in front of us all the time, is a real problem for you. Because you lose the war and the battle in the war. Your integrity matters. It matters a lot also in the civil arena, but in the criminal arena, we see you all the time. And your integrity is vital to being able to do a service to all of your clients, not just the one you happen to be representing at that moment. So you want us to push the law, I get it. Just make it in that context. Don't misrepresent what the law is.
I think that's very well said. I don't begrudge a weak argument. I understand. You've got to zealously advocate and preserve the record. It's got to be done within the bounds of ethics and your role as an officer of the court. That can be a tough line to find, but in my mind, that's the line.
Next question. When I used to be a public defender and now I do mostly to civil litigation. Obviously, my favorite thing is civil discovery disputes. Maybe at West Orange, or for you, what are some do's and don'ts for civil discovery disputes?
I would say stop using boilerplate objections. I know that you're not supposed to do that, the Rule 34 tells you not to do that anymore, but I still see them. And I think it's because people are just using their formats for making objections or responding to discovery. And so they just make these long, rote objections to everything, and that's just not proper. And so you really risk, a judge being able to just say you've waived your objections because you're not complying with the rule. You need to make your objection with specificity, and you need to also indicate whether or not you have withheld any documents pursuant to any objection that you have made, and oftentimes that kind of information is missing. And so the other side is left feeling like you're holding back something by just making these boilerplate objections and not indicating whether or not you have actually produced all of the documents. And so that's a common problem. And then, to just remember to meet and confer before filing any sort of joint letter. I think we all require joint letters now. I don't know if anybody does motions to compel enormous involves a third party. But we can tell when you haven't met and conferred. And so when we get the discovery letter from you, when I read it, it's very clear to me who has met and conferred. And if I can tell that you haven't, I usually get, just terminate it and order you to meet and confer. And then come back to you with all those things that are left after you've gone through a meaningful meet and confer. And I agree with saying it should be substantive. It should have some meat to it. It should be saying, what kind of discussion did you have? What did you offer to resolve the dispute? Did you offer an alternative? Or did you just dig your heel in and say, I don't have to do it? Or no, I'm going to do it this other way. Or just make some unilateral decision to change the time of the deposition, or the number of hours of the deposition, or the location, without actually working together with opposing counsel. And it's very obvious. And then if you end up having to call us, during a deposition, something like that, because the other side is not cooperating or instructing their client not to answer. I'm just blown away by those when I get those calls, because I can't believe that attorneys would instruct their clients not to answer. And they're not instructing their clients not to answer attorney-client privilege things. There are all kinds of things that they're instructing their clients not to answer, and it's just unbelievable to me. So it really undermines your credibility. It interrupts me in the middle of my day. I have to stop whatever I'm doing, get on this call with you to say, you can't do that. So go back to the deposition and stop. And let your client answer the question. You can make your objection for the record and move on. So be able to be cooperative and no more boilerplate objections.
Okay, raise your hand if you really love civil discovery. Yeah, I don't think any of it, really, was there one? Yeah?
I don't.
Good on you.
Frustrating, but it can be satisfying.
Okay, I'll take that. Frustrating but can't be satisfying. I think if you ask the judges, none of us would raise our hands about do you love discovery, because it is that place where there's, it's sometimes there's personality disputes. It's a place where it can be very frustrating. And I'm here to tell you the sad news is that we don't want to, we don't deal with those. We don't see those as disputes that can be adjudicated. Those go back to you. So if it doesn't look like there's been the real meet and confer, if what we get in your joint discovery letter is just kind of like, we're not getting along, I'm sorry, we can't help you. So you've got to go back and give us something to engage with, explain what's relevant, explain proportionality. The joint discovery letters that are the default now are meant to make you do that. And mine has an extra requirement. You must give a compromise. What's your best compromise? Because it tells me that I don't always pick it. Sometimes it's like, no, you get it all because you don't need to compromise on this. But it shows me that you're really working toward it. It's a requirement. And the only things that I really routinely would allow you to be in motion are privilege, because you're going to need to do the law and you need to give me evidence to support privilege. Otherwise, it's the letter. And it's really, you boiled it down to where you need adjudication. And, you know, so be careful about those. There's a lot of them that get sent back. Do over. You're not really engaging.
And again, go back to the standing order, because all of our standing orders are a little bit different. So my standing order has specific requirements for what I want to see in your joint letter. And so those things should be addressed. And you have to start off by saying you did meet with the firm, you're attesting to the fact that you met. And then when you are, I offer you a format for how to structure your joint letter, how to break it down in terms of what the issue is, what the dispute is, and what plaintiff offered to do, what defendant offered to do, and that I want to have a separate letter for each discovery device, because to me, there's nothing worse than one long discovery letter that jumbles a whole bunch of different discovery devices together, and so I can't tell if they're arguing about interrogatories or a request for production of documents or something else, all mixed into one discovery letter. So I like to have a letter for each device, and I know it might be annoying that you have to do that, but it makes it easier for me to do my job. It makes it very clear to me what the issue is that you're still fighting about, that you are still unable to resolve on your own, what your effort was to try to resolve it, what the other side's effort was to try to resolve it, so that I can help you figure out how to resolve it. I can make that determination for you since you weren't able to do this.
Can I also add, for the younger lawyers in the room, that frequently discovery disputes are just power plays. And the other side is trying to take advantage because you're newer and they figure that they can. A plug for the March 6th event. When we did that event many years ago, that was to give you ideas and tools for dealing with that kind of thing. I won't be there. I don't know if that's exactly part of the program, but it was the last time we did it, because there are things you can do as a young lawyer to make it easier to deal with those kinds of disputes.
Just getting Anderson's all the time. You don't hear those generally, but if you look at the docket and see like 6,000 pager entries for discovery dispute, does that impact how you view the case or the litigants?
A little bit. My overall take is the one that my colleagues have talked about. For me, are the parties working together in a way that is functional? Because that speaks to that will show itself in lots of other ways in the case. And so it tends to be a reflection of the relationship that the parties have, and can suggest that there is some problem in that regard.
And where I see its impact primarily at trial, because people will want to relitigate issues at trial, and the answer is no. That was, you either figured it out pre-trial, used an incredible amount of judicial resources to resolve these things, and you either have the evidence, or you don't have the evidence, or you waive the objection, so I'm not going to do it again. And it just gives me an insight that I have of what I have to look forward to in trial, with the nature of the litigators who are being overly litigious. And I would tend to be, with that kind of litigator, much more stern.
So there's benefit to treating others well. That's sort of my theme whenever I go to law schools and I talk to law students who are going to be future lawyers. preparing in our courts, to treat others well. There's nothing weak about treating others well when you're in litigation. You just are on opposing side, you're making the opposite argument, you can still treat each other well. And when I say treat each other well, I mean treat the court well too. Treat opposing counsel well. Treat your clients well. Don't waste their money. Don't waste their time. Don't waste the court's resources. Do things that make the case go more smoothly, that help the court help you figure out the right answer. You know, don't just be litigious for the sake of being litigious. It doesn't do your client any good whatsoever, even though I think you may be thinking you're posturing for your clients. It does not help them in the long run. Try it.
So I have 1,000 more questions, but I want to leave room for the people in the audience to ask their questions. So the last thing I want to ask all four of you, 2 things that you wish you would have known as a litigator that you learned as a judge. Just really, you look like you have an answer.
It's a summary.
I've got a quick one. I was an employment, plaintiff's side employment litigator, and less is more on the claims. Like, because there's a, we were taught if there's a possibility of a claim, just put it in your pleading and it'll get pared away. Wow, no. Not effective.
I guess the one that I would say, echo something that Judge Gonzalez-Rogers said earlier is just understanding the resource constraints of the court. I often joke when 15 people, so-and-so's going to argue this and that, it's 10. It's like, well, there aren't 5 of me. So just, we really do. We're a very tiny law firm, 3 law clerks and a judge, and maybe some externs. And so understanding everything within that concept serves all of the things we've been talking about in terms of efficiency, narrowing, being strategic. Because the reality is, when you're bombarding, if you think you're papering the other side, you're not really. You're papering the judge.
Yeah, I think if I knew how limited the court's resources were, I'd look at things a little bit differently when I was practicing. I had really good mentors who taught me good habits. So I benefited from that, but I didn't have any idea how busy the judges are and the law clerks. And it's a never-ending amount of work. I mean, you guys have no idea. We work all the time, whether we're physically here, or we're at home, or we're on vacation where we're not supposed to be working. But it's endless, the amount of work that we have.
You have to give us the snapshot. You have to make it easy for us to really decide how we can help you solve your problem. And I don't know that I thought about it that way. Well, what can I do to help you solve your problem for your clients? It used to be that lawyers were counselors, not litigators. Your client has a dispute. Well, there's 1 of 2 ways it's going to resolve. You're going to settle, or it's going to go to trial, right? And generally speaking, thankfully, you will resolve your disputes, because we're not trying 700 cases a year, or 300 cases a year. We're not trying all your cases, so that means that something's happened. So the question is, how can we best help you? If you could just help us focus on that, so that you can go do your job and get the case off our docket and resolve the issue for your clients, that would be a wonderful thing. That's the goal. That's the goal of all of us, to figure out how we can help you.
So, questions from the audience? Yes, do we have we don't have a mic.
You don't have a mic, but stand and stand up.
Yep.
And project.
Yeah. Well,
To practice for when you appear in court.
Yeah, absolutely. Well, thank you. So I have a question that I think will intersect with the briefs topic and the civil discovery topic. So as someone whose last name puts them in compliance group 1 for the California Bar, I have been binge watching a lot of PLI videos. And one was on civil discovery, and there was a panel that had federal judges, I think in New York, I think Eastern District and Southern District, and their thoughts about discovery disputes, especially when there's briefing required. The analysis should start and end with Rule 26B. There really shouldn't be a lot of citations to kind of these persuasive court decisions, all these Westlaw unpublished decisions. It should just be that, and then talk about the cases. So I'm curious about your thoughts or preferences about that.
So relevance and proportionality, right? That's Rule 26. So I am always shocked by joint letters that don't actually tell me why the stuff they want is relevant, and don't say much about burden, or say in a very conclusory, this is very burdensome. What do I do with that? So I totally agree. Engage with that. Give me the facts about what you need or why it's going to be hard. And then sometimes there's cases, but the case discovery is so discretionary. It's rare you're going to get a case right on point that's going to really help the judge. It's way more helpful to explain the case.
I would agree with that. Question?
I'm generally in the Eastern District, so I apologize if this isn't as relevant to the Northern District. But what I was wondering is the judge's opinion on Zoom hearings and electronic, like the conduct of attorneys, like things that you see that we can avoid to help make that sort of process easier. So I don't know if you guys depend on it as much as we do, but we have a lot of them, and I would love to hear the court's opinion on that sort of thing.
So I use Zoom for case management conferences. I don't use them for oral argument, and obviously not trials or evidentiary hearings. Used to use them all the time, probably one of the first out of the box. So I don't do much substantive on Zoom.
I just stopped doing my motion hearings on Zoom, so this year now I'm doing them all back in person, and I can just say that it's been a wild ride. Having hearings on Zoom, I feel like I could write a book about all my crazy experiences, the things that I've seen. I still have settlement conferences on Zoom. I'm trying to get more of them to be back in person, but I'm getting some resistance to that. And sometimes it makes sense because people are far away, and it makes sense to save the money and do it by Zoom. But I have seen it all. I mean, people really do tend to forget to respect the proceedings when they're on Zoom because they're at home. Their dogs barking, their cats walking across the camera. They are attending to their kids because they believe that they can just multitask and do court at the same time. And that doesn't work. I've had people in the bathroom, doing their hair. I have attorneys appearing in their car. Sometimes they're actually driving. And it's a disaster. And people are not focused. And it really does take away from the seriousness of, what's before the court, and it's distracting. And if you're outside, there's noise, you can't be heard, you end up having reception problems. I mean, it's just, the problems are endless on Zoom. And so I am only going to continue to do case management on Zoom because I think that's the only thing that's still conducive to doing that, although sometimes I still get attorneys showing up in their cars for case management conferences, but most of them at least are very apologetic, so that's okay. And and people don't dress appropriately anymore. It just sort of degrades the whole process in a lot of ways. So to answer your question, I try to emphasize how important it is for people to treat Zoom as if they were physically in the courtroom And when I have my planning calls to plan for settlement conferences, I make sure to tell the attorneys that even though we're gonna be on Zoom, you need to dress like you're coming to court. You need to tell your clients to dress like they're coming to court, and that they need to give this their undivided attention and not be multitasking and doing other things. And so that helps when I make sure to admonish people ahead of time, because I think it's just something people, they would be thoughtless about.
I think I use it more than maybe some of my colleagues here. I don't use it all the time, but I think it saves the environment. I think it saves costs. It can be a tremendous tool. It opens hearings more broadly to public access. So sometimes they really make sense. Yes, especially early on in the pandemic, there were all kinds of crazy things. What I still see now that I really would put out there is make sure that everything's working. I still, am sort of the, repair lady. You see the carry, now click on that and check my, and it's shocking, and I'll hear a lot of times, well, I'm sorry, I'm not technically advanced. I'm thinking, well, you could, do you have nobody who could help you with this? That's the key one, is just make sure it's all working, make sure you know how to do it. Make sure your lighting's good, but otherwise, I think I can see you. When I can see you, I actually feel like, we can engage pretty well through Zoom for a lot of it.
Yeah, and just echoing exactly what Judge Ryu said, my main point is check in early. If you try to show up with a minute before the hearing and something goes wrong, that's not a good look. So be sure to check in, make sure the tech's working, and build in time to do that.
I think it just depends on the person. It depends on the lawyers. Sometimes lawyers are really good at that, and sometimes they're not, and they're distracted. So it's just sort of a case by case.
We have time for one more question? Yes.
Something's been on my mind lately, and seems to go a lot of different ways with different lawyers, is how do you treat objections to evidence in motion practice? Some people want to object to everything because they're afraid that they don't. Somehow that's going to come back and haunt them, and other people don't do any at all. What's a good middle ground?
I think when you object to every single thing, it really undermines your credibility. I think you need to be able to make well-informed objections that are based on the law, the actual rules of evidence, and not just throwing everything up against the wall to see what sticks. It really does undermine your credibility to do that. So I don't think the judge receives that well. If you're running into attorneys who are doing that in your cases, the judge doesn't receive that.
Kind of rare that you see them ruled on.
Rare to see them
You
ruled on.
see those objections actually ruled on.
Right.
Well, yeah, I rule on mine.
I mean, it depends, the procedural context matters, right? If it's summary judgment, then we do rule on them, even if it's in a more cursory way. And if you have someone who is just attaching everything, and there's no declaration and there's no basis for the evidence, then I think it's appropriate to point it out. At least in our district, you have to make your objections within the context of your motion. So it's important, but again, is it important or not, right? If you're in trial, do you object every single time there's an evidentiary problem? No. You only object when it matters. Same thing in motion practice.
Right, and just having enough of an explanation that A, whittling down is important, and then B, not, we all get these charts, objection, 403, well, okay, what's the actual point? So I think whittling down, focusing on what's important, then gives you the bandwidth to lay it out in some more detail for the things that matter.
Don't be like Jim Carrey in Liar Liar. I love that movie. Objection, Your Honor. On what basis is devastating to my case? What if it is? We did those.
Okay, well, thank you so much. This has been great and informative. Everybody has the standing orders in your materials. I'm sure they'll be memorized by the time you leave the building. And thank you so much for session is in the attorney lounge. It's go out the door all the way to the end of